Come on now.
Whoa, I think she done left. Give us a second. She'll be back. Excuse me. And we all need to you know what I'm saying, shout Ms.Londa out for her birthday. You know, man, I hope that y'all hit in the comments. Happy birthday, Ms.Londa. You know, she 50 today. So hey, some of us better hope we make it there. So let's go ahead and shout out Ms.Londa in the comments. You know, man, tell her happy birthday. She having some technical issues, so I'm sure she'll be back soon here. We're also going to be talking about the state of Minnesota versus, I want to say his name is Lannon Lavar Burndunice. He had a situation where he bought some marijuana from somebody. They got into it. Um, he ended up shooting the man, killing him. And so we're going to be talking to him today. And there is Miss Londa. She can go ahead and take it away for me.
Sorry about that. All right. So today we are going to be talking about Lannon Burndunice. Lannon has been illegally incarcerated in prison for 40-year sentence. He is legally and factually innocent because of the jury found him not guilty of the crime he was charged with. The judge who actually resided over his case is actually, as some of you may know already, uh, Judge Regina Chu. She resided over the Kim Potter trial. Um, Now, she, along with the prosecutor, illegally charged Landon with second-degree murder by ignoring the law and not following the proper legal procedures to add that charge, which was second-degree murder. Judge Chu did not have subject matter jurisdiction, which is power or authority. She ignored the federal and state commission. Landon has filed appeals due to fundamental constitutional rights, protection, immunities, privileges, guarantees under Fifth Amendment, due process clause, grand jury clause, double jeopardy clause, Sixth Amendment due process clause, fundamental fairness clause, timely notice of the charges clause, 14th Amendment due process clause, fair trial clause, equal protection of the law clause, opportunity to prepare a defense clause. Lannon's trial was unfair and he was denied due process and fundamental fairness due to Judge Chu's allegedly being biased against him and partial towards the prosecutor and disregarding his constitutional rights and protection. Judge Chu allegedly committed reversible error by amending the indictment during trial, which is illegal and unconstitutional. The list goes on. I'll be receiving a call from Landon in just a few minutes here. He'll be sharing his story with us this evening and giving the details into his case. Now, because Landon is calling from prison, I'm not sure how much time he will have, so questions will have to wait to the end. If anyone has any questions, concerns, etc., I will be opening the phone lines once Landon is done speaking. Thank you guys for tuning in. He's going to be calling in here at 6:15. If anybody has anything that you would like to share right now, we have a few minutes. If you have any questions, feel free to ask. So you were saying something before I got all booted out and all this extra stuff.
No, I was
You
just
were saying something.
I was just holding it down for you real quick, letting them know what we're gonna be talking about. You gave them a little bit more information than I was able to give them. I just let them know, like, the Minnesota first, Lannon, Burndunice. And also I had to make sure that they spam happy birthday in the comments. You know what I'm saying, to Miss
Thank
Londa.
you.
Because she reached the milestone that some of us really need to be praying that we reach. You know what I'm saying? So you are 50 years young. Amen. I'm trying to get there myself. So yeah, this is a crazy situation. I can't wait to hear this man's side of the story because, of course, he didn't write this paperwork, and we can always be tricked with the government's or the state's uh, indictment
Yeah.
papers and how they word things. You know what I'm saying? So it's definitely going to be a good thing to hear this man's side of the story. Um, and then see what we can do about it. Because if what he's saying is true, maybe he did do it. Well, I believe he stated that he did it, but like he said, it was supposed to be in self defense. So 400 and like what is it, 30 months? That's
Yeah.
a lot of years.
40
That's a lot of
years.
years, especially every 40
Yeah.
years.
Yeah.
I
And
mean, we
I
got we got.
Googled, uh, acquittal because, I don't understand all these court laws and. So I Googled and it says once you're acquitted, like pretty much the case is supposed to be over. So, I just don't understand all the court laws
So
and
he was acquitted,
subdivisions,
and then they
go
recharged
back
him.
and forth. He was acquitted in the first trial. Then they threw second degree murder in, but they didn't enter it the way they're supposed to according to the law.
So basically, they charged him. They tried to charge him
So
twice, but
so basically, it's also double jeopardy as well. And like I said, the list goes on, but it's a lot that they didn't do in laws that they didn't follow. But he'll be able to explain that a little bit more because he you know he my mind is like, oh, okay, that's a lot. I can't remember all of it, but I try to take as many notes as possible.
I mean,
Hello, Veronica. Thank you, Prentice. Thank you, Abe. Thank you, Linda. I'm listening.
Miss Rhonda Johnson.
I didn't already talk to her all day.
In the studio with
Thank
the
you.
Red Boys. Those guys, man. Those guys. Shout out to them, man. Um, you know, it's crazy how it's justifiable when it's they side, but it's not justifiable when it's us. That's what's even more crazier
Yeah,
because you get a man, he can put his knee on a man's neck and basically murder him on camera and get like 10 years. But then I do something and you want to give me 40. And it's like, y'all winning, I guess, because y'all knocking two birds out with one stone. Like, okay, we got one ninja gone, and now we can
yeah.
lock this ninja up for the max. You know what I'm saying? It's like, what? Like, y'all don't even care about the side of the story, how my situation went down. It's just, modern day slavery because now we can give you 8 cents an hour to make license plates and shit like that for your next 40 years.
Jody, you're asking who will tell Josh's side of the story. This is an interview for Lannon, so I'm not. I don't know. I honestly don't know.
I mean,
Thank
that
you,
is a good
Asia.
question.
Yeah, it's a
But
good question,
the
but
whole
I
story,
mean,
I guess the whole story, Jody. If you go and read the transcripts, the story comes from the text messages from Joshua's phone. They got most of the story from his phone. This is how they even came up with their conviction towards
And the
Burndunice,
girlfriend.
and the girlfriend. So, you know,
Yeah.
his story was kind of told if you go read the reports. You can kind of see the story. It came from all the text messages. Um, but well, he's not denying from what I read. He's not denying what went down. I think that he's looking at the discrimination of the courts as far as him saying that he felt like it was self defense and
Yeah.
the court being pure, or being all white, and so he just don't feel like he got a fair case as far as the situation go. Like 40 years compared to self defense, even if y'all give me 20 years or 15 years, it's like 40 years. Like god damn, like you know what I'm saying?
Yeah.
Y'all ain't even get dude 40 years for sitting on dude's neck. But is that because that's your cousin? Is that because that's your homie or something? You know what I'm saying? Like, how come he didn't get that? Or the lady that, you know, mistake their gun for a taser? Like, okay, Miss Veronica Landon is her nephew.
Yeah.
Um, so it's like,
And that's
y'all
the
didn't even
biggest
get.
thing in this situation because resided over her case, resided over his case. Both of
Mm.
their defense was self defense. She got 2 years and she was found guilty of all her charges. He was acquitted of all his charges.
And she was a rookie, right?
So, yes, Kim Potter, T Bone, yes.
She said
Okay, Veronica,
KKK
that's what's up.
KKK party.
You know what? I didn't realize what she was saying. I thought she just accidentally put an extra K there, or he.
That's funny, T-Bone. Oh, the situation happened at
Oh,
your
okay.
house.
So listen is in the comments, and she said it happened at her house. Okay, she was 26 years old, field training. Yeah, Kim Potter. She said.
She said, "Gotta spell it
So you
right."
guys, we're just waiting for him to call in, and then he's gonna be here to tell his side of the story. So yeah.
Yeah, they definitely gonna look out for their own anytime. We know this. Like, um,
Yeah.
I'm not gonna speak on the case. You feel me? I'm damn sure not gonna, because I don't want to speak my thoughts on it because I don't want to speak my thoughts. I want to just let my thoughts be. But what I will say is that I know that people definitely get wrongly convicted. How come you can get? How come this
They
colored
do,
person?
and the thing is, it's not so much as oh he's guilty. The thing is fair punishment. Period. Does the punishment fit the crime? You know
There
what I'm
we
saying?
go.
Like I can't remember the girl's name. But I watched it on Trap Queens. How the hell you get life for white collar crimes? You know what I'm saying? Like, flipping the cards and the credit scores. And how do you get life from that? And they don't get nothing but probation. You know what I'm saying? So it's like the
And then
crimes
still
don't
get to come
fit,
home
the
to the shit.
punishment don't fit the crime.
They still get to come home
That
to the
blue
shit.
wolf
Like
ain't
once
no
they
joke, right?
that's all it is, man. It's
He
like
ain't
it don't even gotta be
qualified
blue oak,
immunity.
honestly, man. I seen a video. I don't even remember what state it was. Some people in the comments might know what I'm talking about. But it was like a white dude walked down the street. He had an AK-47 on his back and like two pistols on him, right? And the police stopped him and was like, "What you doing with that?" He like, "Shit, am I in trouble?" They like, "Nah." He like, "Well, then leave me the hell alone." Like, and they left him alone. But then when the black man did it, and they knew each other. They did this just to do like a little, just to do a little demonstration of the difference on the color, how people they respond. The black did do the same thing with the same exact guns, and the police didn't even get out the car and ask them. They got out the car. It was more than this one police cop. It was about 5 police cars, and they all got out the car, guns drawn on them. They ain't even give you no chance, like, what you doing or nothing. Like, just guns drawn. Like, the one dude could walk off, say, "No, yo, if I ain't doing nothing wrong, leave me alone." To where this dude, he don't even get a chance. He just, like, put your hands in the air. So, uh, this is a dude named Risen, man. I have a gun, and I'm putting that with I don't know what state it was. Some, this is the dude named Risen, man. I have a gun, and I'm putting that. If you black, you should not own a gun because you are putting yourself in a position to be shot. Period. Like they shoot first and ask questions later. So it's like damn, I want to own a gun. Go ahead.
I was just saying true. Thank you. Here he is.
Okay, I'm gonna go quiet.
All from an in. This call is from a collection facility and is subject to monitoring and recording. Thank you for using GTL.
Hello, Lannon. How are you today?
Hi, I'm good. How are you?
I'm doing good. So I gave a brief introduction, and we kind of discussed a little bit, but I didn't go into full details as far as the place that day. I pretty much wanted you to do that because only you can tell your story. You know what I'm saying? So
Right.
the floor is yours.
Okay, so to everyone listening, hello, my name is Lee, and I'm currently incarcerated. I'm currently in prison illegally and unconstitutionally. So I'm incarcerated because of the incident that happened July 19, 2016. So on July 19, 2016, I was selling marijuana to help pay for my college tuition and to support my family at the time when I didn't have a job, when I was in between jobs. And so on that day, I sent out a text message that morning. Sent a text message out to people in my phone who I normally sold weed to, letting them know that I had a new strain for sale. And so the first person to respond was a 31-year-old guy named Josh Hoffman. He responded and asked me for a certain amount for a certain price. And initially, what he had asked for, I told him initially that I couldn't do it at the time. I was trying to get him to come back with a better offer from me. And so, but when I initially rejected his offer, he got mad and sent me some text back where he said, fuck your shit, nigga, and you're a bitch, and don't ask me to buy shit from you ever again.
I just want to cut you off real quick. Nigger. Can we switch it to Ninja? For Facebook, the word Nigger. Can we switch it to Ninja? Facebook and YouTube, they be booting you off.
Okay. Yeah. Well,
Thank
yeah,
you.
that's how it was spelled, Nigga.
Oh, okay.
And so I want to add too that Josh Hoffman, for those who don't know, Josh Hoffman was a white male. And so he said, F your shit, nigga. Don't ever ask me to buy shit from you again, and you're a bitch. And so when I got the text, I laughed, but it was kind of funny to me. I don't know why, but it was funny to me. And I'm like, damn, this guy really needs to smoke. He needs to smoke bad. So I didn't want to lose him as a customer, so I texted him back and was like, you know what? I'll do it just this one time, man. Come on, I understand it's hot outside, because that day it was like 101 degrees outside. I texted him back and I said, you know what? I understand it's hot outside, man. And, I'm going to go ahead and, wave that off. I'm going to let that slide. Come on ahead. Come on over and get it. I got you. Just one time. So he texted back and was like, yeah, man, I appreciate it. Just trying to beat the heat. That's all. I need to smoke. I said, cool. Okay, here's the address. So I gave him the address. He came. When he arrived, he had his girlfriend in the car with him, a white female by the name of Caitlin Schroeder. And so they pull up, and I approach the car, I already had the bag of marijuana in my hand. I dropped the bag in the car because I didn't want to like do a hand-to-hand transaction. So I just dropped the bag in the car so it wouldn't look suspicious, you know, just in case undercover police was in the area or whatever, or you know, just people in general. You know, I didn't want people to see that a weed deal was going on. So I dropped the bag of weed in the car, and it landed on his lap. He picked the bag up, and he starts examining the bag, like fumbling around with the bag, and then he just instantly blows up out of nowhere. Like, I did not see it coming. Like, he just instantly blew up. He said, "What the fuck is this?" He said, "I can't even smell this shit. Da-da-da-da. Why is it in this? Why is it in this plastic? It's not in the normal bag that you put it in." And I responded. I was like, "Hey man, it's all there, man. Just come on, man. It's hot outside. It's all there, man. You know, the police be in this area a lot, bro. I ain't trying to get caught, man. Just come on, man. It's all there." So he was like, "Man, fuck you. I'm not paying this. You're bogus. No, I don't want this. No, I'm not giving you 40 for this shit." And so when he said that, when he said he wasn't paying me for it, I noticed that he never put the car in drive. He never put the car in park. The car was still in drive, and he had his foot on the brake. And so when he said, "I'm not paying for this," I thought that he was going to try to pull off with my weed. So I instantly snatched the weed back out of his hand, put it back in my pocket, and proceeded to walk the way that I came. At that point, ending the transaction, ending the deal. Okay, he said, "You're not going to pay for it, so I'm not, there's no point in me standing out here anymore." So as I'm trying to walk back, to go back to my auntie's house where I was standing, I hear the engine rev up where he done hit the gas. And so instinctively, I kind of like jumped out of the way because I knew that was the motor that I heard. I knew, you know, that the car was still in drive. And so I wasn't able to get all the way out of the way in time until the car bumped me and hit me in my elbow, and made me stumble a little bit. And at that time, I looked and I realized that he intentionally, he tried to hit me with the car. He tried to run me down with the car because the front of his car was pointed towards the garages that were in back of me, basically cutting off my walk with my path to leave. So he had me boxed in against the garages using his vehicle. So then, as I'm getting myself together, catching my I caught my balance and stuff. I didn't fall. As I'm getting myself together, he's like, "Where the fuck do you think you're going?" He's screaming. He says, "Where the fuck do you think you're going? Get the fuck over here. You're a fucking bitch. I'm gonna fucking..." And then when he said, "I'm gonna fucking," that's the last thing I heard him say before he turned around. With his left hand, he turned and was like reaching toward the right side of his waistband. And so when I saw him reach for the right of his waistband, I instantly thought that he had his gun on him. And now, why did I think he had his gun on him? Why did I even think he had a gun? It's because he showed me a gun at one of our previous marijuana deals. I sold him marijuana, which was about approximately 3 weeks before this incident, the July 19th incident. 3 weeks before that, he had showed me a Glock 22 pistol. Okay?
Mm-hmm.
Why did he show me that? Because I asked him, did he know anyone who had any firearms there?
Okay.
He indicated no. He said, "I don't know anybody did have any guns." He said, "No, not at the time." And so he pulled his firearm, this Glock 22, out from the right side of his waistband. Okay. Now on this day, he got in my car. So in the back seat, he pulled this Glock 22 out and said, he didn't point it at me or nothing like that. So he didn't. It wasn't in any type of threatening way. He said that this is my only gun. This is my baby. I can't sell this gun. He said, "This is my baby. I love this gun. and I keep it on me everywhere I go. Okay, and I said, so at that point I was like, okay, well, if you ever change your mind, let me know, I'll buy it from you. And he said, all right, I'll let you know, and that was the end of that transaction.
Okay.
So this day, on July 19th, when I saw, after he had just said, I'm gonna fucking, and then reach to the right side of his waistband, I instantly thought that he got his gun on me, that he could have killed me. Because he just tried to hit me with his car. He just tried to run me down. At the time, I'm still in shock. Like, did this dude just really try to run me over? Like, I couldn't believe it. Like, damn, over some weed? Like, did this dude really just try to run me over? And so, when he said that I'm gonna fucking, and he reached the right side of his waistband, I instantly thought that if I don't stop him, my life is about to be over. And so, by me feeling that way, by me feeling I had no other option, I pulled my gun out and I fired towards his arm. And my whole point in firing towards his arm was to stop him from being able to pull that gun out. Okay? So when I shot, I didn't even realize it because everything was happening so quickly. Everything had happened so quickly, and it was it was something that I wasn't really prepared for.
Right.
So, I didn't wake up that day thinking I'm gonna have to shoot somebody.
Exactly.
And so, everything happened so quickly. I didn't even realize that I had shot 2 times. But I later learned that, when my attorneys came to see me. And so, when I shot, boom. When I shot, and then he took off. He hit the gas. So he drove around these big garages, and when I seen him drive off, that's when I took off running. But at the time, I didn't even know if I had hit him or not. I didn't see if I had hit him or not. So, and the way he took off, I thought in my head, I couldn't, the way he was driving, but he drove around the corner like a NASCAR racer.
Mm-hmm.
And so I didn't think that he was even hit. I'm thinking he's about to come around the garage, and he got his gun out, and he's about to try to do me in. And so I ran, and I got back into where my auntie's enclosure is, and I closed the fence, and I went in out. And so about an hour later, the Brooklyn Center police called into my auntie's house and was saying that I need to come outside with my hands in the air and with nothing in my hands and with my hands in the air. And at the time, my girlfriend at the time, her daughter was at the house, and my little cousin, my auntie's son, was at the house, inside the house with me. My auntie and my girlfriend had already exited the house, and apparently the police had already had their custody. So I let the police know, like, I got a cell phone in my hand. This is a cell phone. Tell them I don't have any weapons. This is a cell phone. And so when I came out, and they told me to come back to their voice, and then I got arrested without incident. And so I went to the Brooklyn Center jail, and they had me down there for a couple of hours, and then I was booked into Henderson County and was charged with felon in possession of a firearm and second-degree intentional murder.
Okay.
So when my attorneys came to see me, like 2 weeks after I had been in the county, that is the first time that I learned Josh didn't have that gun on him. So the whole time, up until the time that my lawyers came and told me that he didn't have it, the police didn't find the gun on him, I was thinking that I just got out of a situation where I just
You have 1 minute remaining.
I just stopped this man from killing me.
Okay.
That was my whole, that was the thought process from the time that I pulled the gun out and I shot him until the time that my lawyer came and told me that he didn't have the gun on.
Are you gonna be calling back?
Yeah.
Okay.
All right.
All right.
Thank you for using GTL.
Thank you for everybody watching. He's gonna be calling back. Give us a few minutes. Thank you, Antonetta. Play music. Their video. They got so many streams.
Hello. This is a prepaid debit call from...
Peter.
This call is from a correction facility and subject to monitoring and recording. Thank you for using GTL.
Okay.
Yeah, hello?
Yep.
Okay, so on August 11th of 2016, I was indicted by Hennepin County Grand Jury that charged me with first-degree intentional felony murder while attempting to commit aggravated robbery and felon in possession of a firearm. And so I pled not guilty and go to trial. So my first trial was, it started September 18th of 2017. And at trial, I asserted self-defense. I asserted self-defense and accidental homicide because when I shot, I was never intended to kill Josh. I was only intended to stop him from reaching for the gun that I believed he had. Called witnesses to testify. One of the witnesses, the only eyewitness to the entire incident, Josh's girlfriend at the time, Caitlin Schroeder, testified that she believed that this was an intentional robbery. That she didn't believe that Josh knew me or that he had ever bought marijuana from me, and that this was a whole setup to rob Josh for $40. Okay, and so I testified in my own defense, and I told exactly what I just told you.
Mm-hmm.
That, yeah, I went out there to do the deal with Josh. Okay, I admitted that, yeah, I was selling weed. I admitted to having the firearm, and that I knew I wasn't eligible to have a firearm because I wasn't licensed. I didn't have a license to carry. So I admitted that. Explained to the jury that the reason why I had the firearm for my own safety, not to protect the drugs or to protect the weed, I mean to protect the money.
Right.
For my own safety, because I feel like a target because I'm selling this marijuana and I'm having large amounts of cash on me at times, you know, and so I feel like a target, you know, the people who like to rob drug dealers.
Mm-hmm.
And so, yeah, so I told the jury the same thing that I just told you, that I never meant to kill Josh. Okay, I didn't wake up thinking I'm going to kill somebody or I'm going to shoot somebody, or if somebody calls me a bitch, I'm going to. That was never my thought process. That never was my intention. Everything happened quickly. It happened, you know, in a matter of seconds. And it turned out to be a very tragic incident. And and I'm regretful and sorry that it even happened. But it happened. There's nothing that I can do to take it back. You know, I wish it didn't happen, but there's nothing I can do to take it back.
Right.
But I did not intend to, definitely wasn't intending on robbing them. I didn't try to rob them, and I didn't intend to kill them.
Okay.
Okay. Now, let me take it back a little bit.
Okay.
At the trial, at the first trial, my defense attorney attempted to have evidence admitted to support my self-defense. And the evidence that we tried to have admitted, we had the evidence we were trying to get admitted had two purposes. One purpose was to support my self-defense theory that I was not the aggressor, and that that Josh had a tendency of acting out violently and aggressively when he can't get drugs.
Okay.
That was the first reason. The second reason why we wanted to introduce this evidence to the jury was to impeach Caitlin Schroeder's credibility, because she had lied. The evidence would prove that she had lied to the Anoka County Court previous to this incident, and so we wanted to impeach her credibility by showing that she has a tendency of lying under oath to the court after she's been sworn, and also to show that she has a tendency of lying to get in trouble. But let me tell you about the evidence that we tried to admit.
Okay.
So the evidence that we tried to admit was a police report where Caitlin Schroeder had filed, where she was where she had gotten an order for protection put on Josh Hoffman because she said that Mr. Hoffman would threaten to kill her, would beat on her, want to pay for drugs. Okay? And so on this one particular incident, about 6 months before the July 19th shooting happened, she had called the police and told the police that she didn't feel safe at the place where they lived together, and that she needed a police escort out of there because she feared that Josh would hurt her, because he had said that he would blow her fucking brains out, and that he just wanted to bash her head with a hammer until she croaked. Okay? And so in this document, in this affidavit that she gave to the police and that she signed, she led up to Josh saying these things to her. She said they were out going to go buy marijuana, and apparently at some point in time she didn't want to buy the marijuana anymore. She changed her mind, and she had expressed that to him, that she didn't want to buy weed anymore, and that she wanted to just go home. And that Josh blew up on her and got to calling her out of her name and, beating up the steering wheel of the car, and said he got to driving erratically and crazy, and was saying that he would kill him, that he would crash the car and kill both of them. Okay?
Mm-hmm.
And she said in this affidavit that this is what he does. He can't get weed, when he can't get his drugs, his stuff. And so we tried to introduce me through my defense attorneys at trial. I tried to get this evidence in to show to support my testimony that this is how he acted when I proceeded to walk away, ending the deal. When I walked away, implying that, okay, you're not about to get these drugs. He lashed out. He blew up. He went from 0 to 100 real quick and tried to run me down with his car, and reach for a gun. These things that she said, that Caitlin said in this document, would support how I described him acting on. Now, Judge 2, the judge presiding over my trial, she barred this evidence from coming in by saying that she said that the probative value of the evidence was not outweighed by the prejudice. That the prejudice that the evidence will cause to the state's case was outweighed by the probative value of me introducing this evidence. And so what that means is that the level of proof, how good it helps my case, is less than the precedent, than how it would state's case.
Okay.
And so she barred evidence, and we argued that the evidence was admissible under the rules of evidence, under the state and federal rules of evidence, but she still barred it.
Okay.
Okay, and so then the prosecutor asked her to allow him to specify my previous conviction. Okay, she told the judge to allow him to specify two of my threat of violence and a violation of a Danko order, but she sanitized one of the convictions. So two out of my prior convictions were able to be told truth, but she didn't allow my defense to say anything about Josh's prior bad acts and about how he acts when he can't get marijuana. Remember, I said that we also had the reason for introducing this evidence was to impeach Caitlin Schroeder's credibility, right?
Mm-hmm.
So she also limited us on how to bring the evidence in to impeach Caitlin Schroeder's credibility. She said, Judge Chu said that we couldn't bring up anything about what Caitlin Schroeder said in the document, and that we couldn't ask her why she lost court on another date in a document that you were sworn to.
Okay.
So that's how she that's that. And so during the voir dire, when we were picking the jury, was about 55 people. There were maybe 2 or 3 black people on the jury. And so on my first trial, one black juror was chosen. It was an African American lady. Every other juror that out of the other 3, it was 4 altogether. Matter of fact, I'm sorry, it was 4. So the other 3 jurors that we were able to interview that were black, the prosecutor struck every last one of them.
Okay.
Every last one of them indicated that they could be fair, they could be impartial, and that they would do their job as jurors, and if they didn't have any prejudices or biases against either the state or myself.
Now, when they deny a person to be a jury, do they have to give a reason?
No, they don't have to give a reason.
Okay.
If they want to get a jury member struck for cause, then they have to produce a reason because they're asking the court to strike the juror for cause. But if just for them to strike a juror, no, they don't have to give a reason unless I challenge the strike, unless the defendant challenges the strike. So on one particular African American male, we did raise a Batson challenge in the first.
You have 1 minute remaining.
In the first trial. So what a Batson challenge is, the Batson rule came out of a U.S. Supreme Court case, Batson versus Kentucky, where the U.S. Supreme Court ruled that racial discrimination in jury selection is prohibited. That a prosecutor can't use a peremptory strike to remove a black juror solely based on his or her skin color. And so we raised this challenge because the black man that he struck did not indicate first of all, he spoke good English. He understood. He had a good enough understanding of law terms, legal terms, and there was nothing.
Thank you for using GTL.
So I'm sure he's gonna call back. Let me read some of these comments. So Veronica says in Brooklyn Center, police messed up my house, opened up a bag of sugar and dug in it. They was doing dirty stuff. Let's see here. He was trying to kill my nephew with that car. And Josh and his family are known racists and drug users. T-Bone says there was no hand-to-hand.
Yeah, when he come back. So what I'm thinking is, like we had discussed earlier, we really just looking at the time that they trying to get this man. As far as the situation, it seems like when a white person kill a black person, you know what I'm saying? It's like 10, 12 years, 15 years, whatever, you know what I'm saying? Where you about to take this man half of his fucking life away, man. That shit is. And like, I'm pretty. How does he know? Like, you want to be coming home to about 70?
This is a prepaid debit call from.
So go ahead and handle that.
I don't think he's 70.
No, I'm saying he won't be coming home till he's about
This
70.
call is from a correction facility and is subject to monitoring and recording. Thank you for using GTL.
Okay.
Okay, so there was nothing to indicate that this man would be biased or impartial towards either party in this trial. The man described an incident where, because he was a U of M student. And so he described an incident where, because I believe the question was asked, has he ever, and this is a question that we asked all the jurors that we interviewed. The question was that he had any kind of encounter, negative or positive, with law enforcement.
Mm-hmm.
So the man described an incident where basically he was racially profiled and racially discriminated against by University of Minnesota Police Department.
Okay.
He described the incident where there was a college party happening, and he was out there with friends and stuff. He indicated that the friends he was with were all white, and that this this University of Minnesota police officer approached him and asked him for his name and his identification, and then proceeded to get rough with him, like roughed him up and slammed him on, I believe he said he slammed him on the car or against a brick wall or on the ground, something. He slammed him somewhere, and that he had done nothing wrong, and he couldn't understand why this was happening to him, and that, that gave him a different outlook, a different perspective on law enforcement, because he was subjected to that type of cruel punishment, when he wasn't doing anything, that his white counterparts weren't doing. They were all out there partying, but he was the only one who was subjected to police harassment and police brutality.
Okay.
And so he described the situation, and then both my defense attorneys and the prosecutor both asked him, would this affect your ability to be fair in this process towards the state, toward the prosecutor? He indicated, no, I wouldn't let that affect me. That happened to me, but it has nothing to do with this. I'm going to go off of the evidence. I'm going to go off of the facts. I'm going to go off of what I hear in this trial. Nothing is not going to affect me. And so the prosecutors used a peremptory strike to get him off the jury, and we raised the Batson challenge, saying that we raised the Batson challenge, arguing that the use of the peremptory strike, the prosecutor struck him because he was being racially biased, because the man was black. Point blank period. There was no other reason to strike him other than the fact that he was black.
Okay.
And so Judge Chu overruled the Batson challenge and said that she didn't see anything wrong with him striking this black man. Said that there is a possibility that he would be biased towards the state. Even though the man had just said he wouldn't be biased or impartial towards the state, Judge Chu agreed with the prosecutor, saying that there's a possibility he could be biased because he had this negative interaction with a police officer.
So let me ask you this. In a case like that, okay, so they dismissed him. Are you allowed to ask for another black juror to be brought in?
No, the court pulls the jury. They have a process of doing that. They pull the jury, and we have nothing to do with that. So who they pick is who they pick to come in.
Okay.
And we just have to interview the defense and the prosecution have to sit through and go through and pick and discard what jurors we want and we don't want. And so yeah, we have nothing to do with how the jurors get picked.
Okay.
Okay, so all right, so the trial proceeded. Indicated Caitlin Schroeder testified, and then I testified. And so that first trial, the jury deliberated for 4 days. And on the fourth day, wait a minute, during those the days of deliberations, the jury came back with 2 jury questions on separate days. So both jury questions had to do, one of the jury questions had to do with the jury instructions that Judge Chu gave them. They were confused by the jury instructions that she gave them.
Mm-hmm.
And what they wanted to know was, did all of the attempt elements have to be proved to prove aggravated robbery, and did the aggravated robbery have to be proved to prove the first degree murder? Now, mind you, at this time, this is the first trial. So, in the first trial, the jury was instructed that they could charge me, that they could find me guilty of first degree felony murder while attempting aggravated robbery and felon in possession of a firearm, and second degree unintentional murder while attempting to commit aggravated robbery. So they were charged with 3 things in the first trial, 2 of which were included in the indictment, 1 wasn't included in the indictment.
Okay.
And so in that trial, the jury, after they so the question that they asked about the jury instructions, Judge Chu didn't define the terms that they were asking for definitions for. She just told them to go back and reread the jury instructions that I gave. Okay, so she didn't instruct them any further. She just said, go back and read what I gave. Okay, so they go back and they deliberate a couple more days, and then they came back on the 4th day and said that they had reached an impasse and that they were hopelessly deadlocked on the first-degree felony murder. And so my trial attorneys asked Judge Chu to ask the jury did they come to a verdict on any of the counts. Remember, they were charged with 3 counts. And so the prosecutor objected. He wanted a unanimous verdict on all of the counts. He didn't want to accept the partial. Wanted the court to accept the partial verdict, but Judge Chu said she would ask them. And so she brought the jury back in. She asked the jury, "Did you guys reach a verdict on any of the counts?" And the jury foreperson said yes. Okay. She asked them on what count, and so he went back to the room and got the verdict form and came back, and the Judge Chu read the verdict form. And on the verdict form, the jury had indicated that they found me guilty of ineligible possession of a firearm due to the fact that I admitted on the stand that I had the firearm in my possession and that I was ineligible to possess it due to my prior conviction. And so Judge Chu never said whether she was accepting that partial verdict or not. She just asked them, "Did you reach a verdict?" And she just read the verdict form. Okay, and so Judge Chu asked the jury, "So would further deliberations help you in reaching a verdict on the murder count?" And the foreperson indicated no. So at that time, Judge Chu thanked the jury for being there and for their service as jury members, and she told them they could leave. She discharged them. Okay, and so as soon as the jury was gone out of the courtroom, Judge Chu immediately went into asking the prosecutor and asking my attorneys what date would work for them to reschedule, to retry me on first-degree murder. Okay, and my attorneys stopped her and asked her to move for a motion for a judgment of acquittal based on insufficient evidence due to the fact that the jury wasn't able to come to a verdict on the murder count.
Okay.
Okay, Judge Chu denied the motion. She said, "No, I think that another jury can find him guilty of first-degree murder." And so she rescheduled the date for February the 26th. Okay. Now, before February 26, 2018, which was the second trial date on the same first-degree felony murder count, my attorneys filed a motion to dismiss the felony murder count based on grounds of double jeopardy under the United States Federal Constitution, under the Fifth Amendment, and under the Minnesota Constitution, Article 1, Section 7, double jeopardy clause, and under Minnesota Statute Section 609035, Subdivision 1, which is a state double jeopardy statute. And so the grounds for the motion to dismiss were that in the first trial, the jury came back, they reached a verdict on one of the counts that were included in the indictment, which was the ineligible possession of a firearm. They came back with a guilty verdict on that charge. So I was convicted of that charge.
Okay.
So the argument is because under federal and state law, because the jury reached a verdict on one of the counts in the indictment, it terminated the jeopardy in the indictment of the proceeding in the indictment. Okay, so under those circumstances, when jeopardy is terminated, the prosecutor, the state is barred from retrying a person after jeopardy has been terminated by either a conviction or an acquittal. So those are the only two things that can, three things that can terminate jeopardy: acquittal, conviction, or dismissal of the case.
Okay.
Okay. So in the first trial, my jeopardy was terminated by the conviction on the ineligible possession of a firearm. Okay? Now, federal law allows for a person to be retried on other charges contained in an indictment when there's a hung jury, which in my case, the jury was hung. They were deadlocked on the murder. They couldn't come to a unanimous verdict because they were hung. So federal law still allows for the state to retry a person in those circumstances. However, Minnesota created an exception to the federal law in a case called State versus Law, a 2000 case out of the Minnesota Supreme Court, where they stated that in a trial involving multiple counts, where a judge accepts a partial guilty verdict on one of the counts, but fails to declare that trial a mistrial, that action by the judge it constitutes an implied acquittal on the rest of the counts. Okay? Where a judge fails to declare that trial a mistrial, but she accepts a partial verdict, it's an implied acquittal on the rest of the counts.
Okay.
It's implied that the defendant is not guilty on any other charge. Now, remember I told you that after the jury said that further deliberations wouldn't help them on the murder charge, Judge Chu thanked them for their service and dismissed them out of the courtroom.
Mm-hmm.
Judge Chu never declared on the record.
You have 1 minute remaining.
Judge Chu never declared on the record that trial was a mistrial.
Okay.
She never said I'm declaring this a mistrial by hung jury. That's not in the record. It's nowhere in the record. Nowhere in the trial transcript.
Right.
So under State versus Large, the prosecutor was barred by double jeopardy on retrying me on the first degree murder because Judge Chu didn't declare the first trial a mistrial. She just dismissed the jury and set another trial date. But she accepted that partial verdict. So that conviction terminated the jeopardy in my first trial. So therefore, double jeopardy barred a second trial. But Judge Chu allowed me to be tried a second time.
Okay.
So she dismissed my motion. She dismissed my motion to dismiss on the double jeopardy argument I just described. And
Thank you for using GTL.
They're not even allowed to wear it.
So how you feeling? How you feeling overall, Ms.Londa?
Well, I don't just all the subdivisions and all that. Now, I ain't even gonna sit up here and act like I know what all that means. I ain't even front. I try to Google as much as I can, but I understand what he's saying.
I feel him on the racial discrimination. I understand all that. I think that.
But now, watching TV and watching cop shows, I do know, like, when it's a hung jury or a mistrial, they do announce that. They don't just dismiss the jury without announcing that. I do know that much. So, I mean, he got some strong points.
I think that he definitely listen. I gotta be unbiased on the situation, man. I think that he definitely. I think he put himself in this position.
This call is from a corrections facility and is subject to monitoring and recording. Thank you for using GTL.
Okay.
Have me by my phone too.
okay, so Judge Chu allowed me to be tried again on the first degree felony murder count on February 22nd, 2018. So basically, the same thing as far as like the testimony and stuff, same thing happened. It was basically a repeat of the first trial as far as the testimony is concerned. Now, at the beginning of the second trial, we had to select a whole new jury again. And so the jury pool was about the same. It was about 4 or 5 black jurors that we interviewed to select for the jury selection. It was a couple of Hispanic people, a couple of Asian people, and I think one Native American who got chose on the jury, but the rest was predominantly white. Okay, 50 people. So we got to one of the prospective jurors, and she was a young African American woman from Minneapolis, Minnesota. Her name was Beverly Emerson. So when me and my defense team questioned Ms. Emerson, she affirmed her belief that the justice system was fair because she believed everyone got a chance and was treated equal. Ms. Emerson testified she had never had a bad interaction with the police and that she had no preconceived notions about my case and was interested in seeing how the system works. So we asked her, had she ever made a really big life decision, and in which Ms. Emerson discussed a very intimate and personal decision she made as a young woman involving keeping the child that she was pregnant with.
Okay.
And so we had a lunch break, and after the lunch break, the prosecutor came in and informed Judge Chu that Ms. Emerson had stated in her written questionnaire that she didn't know anyone close to her who had been arrested, charged, or convicted of a crime, but that he had discovered that a man that he believed to be the father of Ms. Emerson's child had a fairly lengthy criminal history. So the prosecutor asked, based on this information, he asked the district court to question Ms. Emerson about this, and the court agreed to do so. Okay, so when Ms. Emerson came in, back in from the lunch break, Judge Chu, now the prosecutor asked her to ask this question because he had a concern about her being biased or prejudiced towards him if he would have asked the question. So Ms. Emerson came in, and Judge Chu told Ms. Emerson that she went and did the looked into Ms. Emerson's background, that she did some research on her and found these things out about this guy who they believed was her child's father. Okay?
Mm-hmm.
That was a lie because Judge Chu didn't go look up anything. The prosecutor did. And so, but she made Ms. Emerson believe that she went and did the research and found this information out. So when Judge Chu questioned Ms. Emerson, Ms. Emerson acknowledged that the father of her child, who she at the time lived with, probably had a criminal record, but told the court she didn't know what crime, if any, he had been charged or convicted of.
Mm-hmm.
So then Judge Chu went into detailing the crimes that he was charged with and the crimes that he was convicted of. And so after she named the charges, Judge Chu asked her, were you aware of any of those charges? In which Ms. Emerson indicated, no, we moved in together, at the end of 2015. And so Judge Chu asked Ms. Emerson, were you with him at the time that that he caught the charges? And Ms. Emerson indicated that she wasn't sure, that she didn't know, and that he never told her anything about, him catching these charges or being arrested, And Ms. Emerson had also indicated that, they even though they had, she had a child by him, they didn't have the closest relationship. That they didn't really, get close until after the baby was born. And so Judge Chu kept asking her, he never told you about this, didn't know anything about it. And Ms. Emerson kept telling the court, no, I didn't know anything about it. He never talked to me about it, but we sure are going to talk about it tonight. And so after questioning Miss Emerson on the on this topic further and receiving the same responses, the prosecutor asked Judge Chu to strike Miss Emerson for cause because he didn't find the claim credible and that she should have been aware of all these issues with the man that she was living with and who was the father of her child. So Judge Chu denied the motion to strike Miss Emerson for cause, and Judge Chu said, "I watched her. She didn't look like she was lying about not knowing. I understand it's probably unlikely. I mean, that surrounding circumstances would suggest that it's unlikely that she would not know, but it's also, conceivable that he didn't tell her. So no, I'm not going to grant the call for a strike call."
And so the strike was you and your attorney wanting to remove her, correct?
The prosecutor was trying to get the judge to remove her, but he
Okay.
didn't want to use a strike, but he was trying to get Judge Chu to remove her.
Okay.
Because by the time we got to Miss Emerson, he had already used about 2 or 3 of his strikes on other black people
Okay.
and one Hispanic person. And so the prosecutor, he then removed Miss Emerson with a peremptory strike, and then we made another Batson challenge. So in support of this challenge, my defense lawyers argued a prima facie case of racial discrimination existed because Miss Emerson, like myself, was black, and the jury pool was predominantly white. And also, we argued that Miss Emerson was subjected to a level of scrutiny that we hadn't seen any other white juror be subjected to. Because even after the court was grilling Miss Emerson about the situation about her baby father, the prosecutor then hopped in after the court and kept on asking her questions, trying to trip her up, trying to get her to lie, trying to catch her in a lie and stuff like that. Mm-hmm. But it didn't happen that way. She didn't lie about anything. But he kept trying to, confuse her and, ask redundant questions and stuff.
Okay.
So we also argued that Miss Emerson said nothing that would give the state reason to question her impartiality, because she said she wanted to see how the system worked and she believed that the system was right because it gave everyone a fair chance. So the prosecutor, he denied subjecting Miss Emerson to greater scrutiny than other jurors and claimed that there was no pattern of the state striking minority jurors, which was a lie, because he had struck 3 or 4 minority jurors before Miss Emerson.
Okay.
And so Judge Chu found no prima facie case of purposeful discrimination because, I quote, "The state has not gone through the process of attempting to eliminate all potential jurors of color." And, I quote again, "because the state has articulated the reason for its strike, and it has nothing to do with Miss Emerson's race." End quote. And so Judge Chu, she went on to say that even if a prima facie showing had been made that the state provided a race-neutral reason for the strike and that the defense had not proven the reason was a pretext for racial discrimination. Now, let me tell you a little bit about how the Batson challenge goes. Okay, so in the Batson challenge, so I raised a Batson challenge against the prosecutor saying that he's striking jurors based on their race because they're black. Okay? And so once I do that, I raise the prima facie showing of evidence by saying that he struck her because she was black and she didn't say anything that would indicate that she's impartial. And so at that time, once I say that, then the state, the burden is on the state. The state has to come back and rebut it with evidence showing that he's not purposefully eliminating black jurors.
Mm-hmm.
Okay? And so once he does that, I have to come back, the defense has to come back and show a pattern of him doing it. Okay? Judge 2, after I show a pattern that he does it, then the prosecutor, I'm sorry, not the prosecutor, but then the judge has to come behind me and then weigh out both sides and determine whether I have shown that the prosecutor has conducted a pattern of eliminating potential black jurors or eliminating a group of people based on their race, right? Now, those are the 4 steps to a Batson challenge. So I didn't even get to step 3 before Judge 2. I didn't even get to explain the pattern of him eliminating black jurors. I didn't get to say he eliminated juror number 5, he eliminated juror number 2, he eliminated juror number 10. I didn't get to show the pattern because Judge 2 cut it off right there, right after the prosecutor stated his reason for the strike. She just went right along with him and cut me off and didn't allow my attorney to even go any further. Okay?
Okay.
And so Judge 2 allowed, denied my Batson challenge and then allowed the prosecutor to strike Ms. Emerson. So Ms. Emerson wasn't on the jury.
So.
Okay, so the end of that trial resulted in the jury came back with a not guilty verdict on first-degree intentional felony murder while attempting to aggravate a robbery. They came back with a not guilty verdict on second-degree unintentional felony murder while attempting to aggravate a robbery. But they came back with a guilty verdict on second-degree intention alone. Now let me tell you about the second-degree murder. So at the end of the trial, at the closing of the prosecutor had wrapped up his case. Right before the judge was about to give the jury instructions to the jury, telling them what they could charge me with and how they could charge me with it, what they needed to find to charge me with it. The prosecutor asked Judge 2 to submit the charge of second degree. At that time, I objected. I said that it was too late in the case. The case had already started. That it would violate double jeopardy under and that it would violate the law of the case doctrine because the jury was not informed of this charge at the beginning of the trial, and that the prosecutor was surprising me with this charge.
Okay.
Judge 2 denied my motion, denied my objection, and said that I believe that there's enough evidence to find him guilty of second-degree murder if they don't find him guilty of second-degree murder.
Yeah.
And so she submitted the jury instruction in, allowed it to come in, and so they found me guilty on second-degree murder.
Thank you for using GTL.
Any questions, anyone?
And real quick to the people that's watching, I'm pretty sure y'all probably seen me smiling or whatever, man. Somebody was texting the hell out of me, man. So I'm not smiling at anything that he got going on. I'm getting crazy texts right now. So, but yeah, his situation is definitely wild. It doesn't sound like racial discrimination, man. And I definitely feel like, I mean, if you did something wrong, you know what I'm saying, you definitely should be tried for it. But I do not feel like you should be discriminated against because of your color. Like, as a black man, I'm not about to sit here and say that all black men are correct at what they do. I'm not going to try and like defend every black man on what they've done, but I definitely will say that I know for a fact that we be tried much harder than our counterparts. So, I feel for
Yeah.
this man. I'm pretty sure he got kids and a family, and you about to have to do 40
Thank you,
years,
Timo.
possibly. You know what
Yeah,
I'm saying? That's
yeah.
like that's not cool, man. It's not cool, especially when y'all, throwing all these little bones and stuff in. We can't do that. I'm not sure how long this man's money is. I don't know how much money this
Yeah.
man got. I'm sure they railroad this man.
And then, well, see, he's pro se, so he basically is he's defending his own case. So that probably plays a big part in it too.
Cause they gonna throw
But he
some. They gonna
sounds,
throw
I
some
mean, he
cool money.
sounds like he knows a lot about the law that he studied up, and he knows, his stuff though.
Definitely do. Is he calling back?
Uh, I think so. I hope so. Because I wanted to get into his appeal process. If he doesn't, then I'm going to take some questions, and we'll probably just have to do a part two. 'Cause it's a lot. Like I said, it's a lot that he's got the Hernandez law 609.35. It's called the explanation that swallowed the rule. There's double jeopardy. Oh, there we go.
Debit call from
Yeah.
This call is from a collection facility and is subject to monitoring and recording. Thank you for using GTL.
Hey, Landon. I don't know how many more times you could call back, but I definitely want to get into like your appeal process and everything that you're appealing. But I'll let you finish off where you left off at.
Okay. So during closing argument, okay, after the judge had let the second degree intentional murder come in to the jury instruction during closing argument, the prosecutor changed his theory of the case from what he was arguing in the first trial. Now, after he had done heard my testimony and heard what my defense is, and so initially he charged me with first degree felony murder while attempting an aggravated robbery. And so that's what he said in the first trial, in closing argument. He said that this wasn't a drug deal, that this was a trap, and that this was a trap to rob Josh Hawkins over $40. That the whole thing was a trap, it was a setup for a robbery. Okay?
Mm-hmm.
So in the second trial, when the second degree intentional murder came in, he changed, well, I won't say he changed, he added another theory to the case. So although he was still arguing, hey, find him guilty on first degree murder because you should believe that it was a robbery because Caitlin Schroeder told you it was a robbery. And sometimes, the prosecutor said sometimes somebody's just lying, and in this case, the only one lying is Mr. Burndunice. And so he said, the prosecutor said, why does she have a reason to lie? A person who doesn't have a criminal record, a person who doesn't have anything to lose. He said he's a 3-time convicted felon on trial for murder. You better believe he has something to lose. He told the jury that if you don't convict him of murder in this trial, you're not doing your job as jurors and you're letting the killer go free. He said if you don't believe that this was an aggravated robbery, then find him guilty of second degree intentional murder. But if you don't do that, then you're letting the killer go. You're letting the killer skate free. You're letting him skate a murder case. And so the jury came back with a guilty verdict on second-degree intentional murder. So at sentencing, the prosecutor asked Judge Chu to use this sentencing method called the Hernandez method to sentence me on the second-degree murder and ineligible possession of a firearm separately, and then to sentence me on the firearm possession first, and then to use that conviction as a prior conviction to enhance my criminal history score, which was 4 points at the time. I had 4 felony points. So the prosecutor asked Judge Chu to use the possession of a firearm offense to enhance my criminal history score to be used to sentence me on the murder charge, to sentence me to the statutory maximum on the murder charge. My lawyers objected to the state's request and cited a bunch of different reasons why Judge Chu should separate the charges, because it was all a part of a single behavioral incident, and why the conduct in my case was less onerous, less serious than typical second-degree murder cases. That although Minnesota does not recognize imperfect self-defense, other states do, and that in another state, my murder charges would have been dropped either completely, dismissed completely, or dropped the manslaughter charges based on the imperfect self-defense theory. And that meaning that a person reasonably believed that their life was in danger and that they had to act in self-defense to avoid imminent danger or death.
Okay.
But Minnesota doesn't adopt that theory of self-defense. They only adopt a straightforward self-defense. And so Judge Chu, she dismissed my sentencing arguments, and she did what the prosecutor asked her to do. So she used the ineligible possession of a firearm conviction as a prior conviction to enhance my criminal history score, raising my points to 5.5 points, and then she sentenced me to second-degree intentional, 40 years to second-degree intentional murder.
Now I wanted to ask, you said the prosecutor instructed her to sentence you to send, what did the prosecutor ask her to do again?
So he asked her to sentence me using the Hernandez sentencing method.
Okay. Now, is that legal for a prosecutor to instruct the judge?
He can ask her, he can recommend sentencing, yeah.
Okay.
That's not illegal.
Okay.
For him to recommend the sentence. But it was illegal for Judge Chu to follow his recommendation.
Okay.
So his recommendation violated my constitutional rights.
Okay. So let's get into your appeal process.
Okay, so I filed a direct appeal immediately. And my attorney, my appellate public defender, he raised a couple issues, and then I raised a few issues pro se on my own. So the issues that my appellate attorney raised was that the jury selection, that the prosecutor's purported reason for removing Ms. Emerson was an obvious pretext for racial discrimination. So it was an excuse for him to racially discriminate against her by dismissing her from the jury. That was the first issue. The second issue was that the district court violated my constitutional right under the 14th Amendment to present a complete defense by excluding evidence showing that Josh's violent and aggressive character and past pattern of aggressive and threatening behavior.
Okay.
Third, that the district court committed reversible error by allowing the state to specify the nature of my prior conviction for violation of a Danko order and threats of violence to impeach my credibility.
Okay.
The fourth issue was that my conviction for the possession of a firearm must be vacated and that my case should be remanded for resentencing on the verdict count because Judge Chu discharged the jury without completing the guilty verdict for the possession of a firearm and without providing me with a reasonable opportunity to poll the jurors to make sure that that the verdict was all of their verdict.
Okay.
That the verdict was unanimous. Then I raised several issues. My issues were that the evidence was insufficient to support the murder conviction, and that also that the jury's guilty verdict for second-degree intentional murder goes against the weight of the evidence. I also raised cumulative prosecutorial misconduct and cumulative judicial errors, misconduct, and bias on Judge Chu's part.
Okay.
So we filed that with the Minnesota Court of Appeals, which denied my appeal, my direct appeal of conviction and sentences. They ruled that my issues didn't have merit and that the district court did everything properly, but they didn't see any violations. So then we petitioned the Minnesota Supreme Court to review the Court of Appeals and the district court's decision, and the Minnesota Supreme Court denied review.
So that's two courts. How many appeals do you get?
And state court,
Just all together? Because doesn't it go like in like a process? It's like, which is the highest court? Isn't it the Supreme Court?
yeah. So the United States Supreme Court is the highest court in the nation. That's the highest federal court.
So once they deny,
court,
does that mean that that's just it, or can you still appeal
no.
again?
No. So the Minnesota Supreme Court denied my petition for review, and then I filed on my own. I filed a petition for what's called a petition for writ of certiorari to the United States Supreme Court, asking the Supreme Court to review the Minnesota court's decisions, the Court of Appeals and the District Court. So they denied my petition for writ of certiorari. They didn't indicate why they denied it. They don't have to. The Supreme Court only reviews about 1% of the cases that come through their court for a year. So they don't have to provide a reason why. But them denying it doesn't mean that they're giving an opinion, that they are ruling on it. They're not saying that my issues aren't valid. They just denied it for whatever reason. They just didn't feel the need to review the case.
Okay.
So after that, I filed in November of 2019, I filed a petition for a writ of habeas corpus in the federal court in the United States District Court for the District of Minnesota. Raised all the issues that I raised on my direct appeal. And so I had the court to stay those issues. So those issues are on hold right now. They're pending in the federal court because I wanted to exhaust other issues, new issues that I found out about through my own due diligence in the state court. So those issues I filed a sentencing motion under Minnesota Rules of Criminal Procedure 2703 Subdivision 9, which is a procedure that can be used for a district court to correct a sentence that is illegal, unconstitutional, or unauthorized by law at any time. So I filed a motion for correction of my sentence on April 23rd of 2021. In that motion that I submitted to Judge Chu, I raised a few grounds on why my sentences are illegal and unauthorized by law and then unconstitutional. The first issue that I raised was that the district court violated Minnesota Statute 60904, Subdivision 1, Paragraph 4, which is a double jeopardy statute that says that where a person
You have 1 minute remaining.
It says where a person is convicted of multiple counts, counts that are included in the other count can't be sentenced, or the convictions can't be entered all together, that you have to choose one of the convictions and only sentence on that one. So my argument for that is that under 60904, Subdivision 1, Paragraph 4, the felon in possession of a firearm charge isn't included offense of the second-degree murder charge, because you can't prove the second-degree murder charge without proving that I possessed a firearm first. And so what that statute says is that you cannot be convicted of the crime charged and an included offense. You can only be charged with one. So that's my first argument on the sentencing motion. My second argument is that if you were going to...
Thank you for using GTL.
So he probably gonna call back one more time.
Yeah. I think Stacy, I think he answered the question about the appeal. Wallaby, I think he answered your question. Thank you, Tiana.
The prepaid debit call from
Peter.
This call is from a correction facility and is subject to monitoring and recording. Thank you for using GTL.
All right. So, all in all, how many appeals do you plan? Like, so what is your next step? Let's talk about that. They denied 2, so what is your next step?
Okay, so on the motion that I was just describing, Judge Chu denied that motion for a sentence correction, and so I appealed her decision to the Minnesota Court of Appeals, explaining why her decision was erroneous and why my sentencing relief should be granted. And so just on May the 2nd, the Court of Appeals came back with a decision where they affirmed Judge Chu's denial of my motion, saying that Judge Chu, the sentence was proper, and that nothing was done wrong, and that my issues are without merit. Okay. Now, also, I filed a petition for post-conviction relief under Minnesota Statute Section 590.01. And what that is that's a vehicle, it's an appellate vehicle for people to challenge their conviction in their sentence after they had taken a direct appeal, or if their direct appeal isn't available. So in that, in the petition, I'm challenging my second-degree murder conviction under the grounds that the district court didn't have jurisdiction, that they lacked subject matter jurisdiction to convict and sentence me to 40 years on second-degree intentional murder because that charge was never included in my indictment. The law says that a person can only be charged on charges that are included in the indictment. The prosecutor never included second-degree intentional murder in my indictment. And after the first trial, there was a 4-month gap between the end of my first trial and the beginning of my second trial. During that time, he never went back to the grand jury to get me reindicted on first-degree murder, and he didn't go back to indict me on to add second-degree intentional murder into the indictment.
Okay.
Now, in Minnesota, the prosecutor doesn't have to indict you to charge you with second-degree murder. He can charge you by complaint. Okay?
Mm-hmm.
But the only way a person can go to trial for any type of charges is the prosecutor has to formally charge you by complaint, indictment, or tab charge. In Minnesota, at least, that's how it has to be done. It's mandatory. So in my case, the prosecutor he never recharged me with the second-degree murder by complaint, and he never went to the grand jury and got me indicted on second-degree murder.
Okay.
And after the first trial, he didn't go back after jeopardy had terminated in the first trial due to the possession of the firearm conviction. He didn't go back and get me reindicted for the first-degree murder as required by law. So therefore, the court didn't have any jurisdiction to retry me for first-degree or second-degree murder because a new indictment wasn't issued. And so, also in my post-conviction, I'm raising the issue that by Judge Chu submitting the second-degree intentional murder jury instruction to the jury at the end of the trial, after the jury had been impaneled and sworn, that action constitutes a constructive amendment to the indictment, which is illegal and unconstitutional.
Okay.
The U.S. Supreme Court has held for over 100 years that a court is not allowed to change an indictment. That once a court changes an indictment on its own without going to the grand jury, the indictment is no longer the original indictment. And therefore, at that point, there's nothing left that can be charged. Okay?
Mm-hmm.
A trial on such an indictment is a void trial.
Okay.
So my argument is that by her constructively amending my indictment, she forfeited jurisdiction. And she lost jurisdiction. At that point, nothing can cure that defect. So my conviction and my sentence of second-degree murder is illegal and unconstitutional because the judge altered my indictment on her own. The law says the Fifth Amendment to the U.S. Constitution is that only a grand jury can change an indictment. Only a grand jury can bring charges into an indictment. The prosecutor can drop charges from the indictment, but he can't bring charges into the indictment without going to the grand jury. So boom, I got that issue. And then I'm also raising the double jeopardy issue that the second trial was barred by double jeopardy because there was a partial verdict. The judge accepted that partial verdict, and she didn't declare that first trial a mistrial. I'm also raising prejudicial variance because the prosecutor changed his theory of the case from the theory that I was indicted on.
Okay.
So the law also says that if the prosecutor changes the theory of the case or the theory of the evidence from that in which was that the person was indicted on that was presented to the grand jury, then that constitutes a constructive amendment too because you're altering the indictment. So basically, I was convicted on a theory other than what the grand jury indicted me on. And that's illegal. That's unconstitutional.
Okay.
And so I'm also raising prosecutorial misconduct because the prosecutor lied at sentencing about a factual scenario where he stated that Ms. Schroeder, Josh's girlfriend, pointed to a nearby townhouse and indicated that I had ran into the townhouse. Ms. Schroeder never testified to that. She never said anything like that. Ms. Schroeder said that she didn't see what happened after the shots were fired. So that was something made up by the prosecutor in order to influence the judge to follow his sentencing recommendation.
Okay.
So he gave knowingly false information to the court, knowing that it was false. And then I also raised ineffective assistance of both trial and appellate counsel for their failure to raise the issues that I just told you about on the sentencing motion and on the post-conviction. So Judge Chu denied my post-conviction petition, and I appealed that decision. And so that appeal is currently pending in the Minnesota Court of Appeals.
Okay.
And so she denied Judge Chu denied my petition using this case called State versus NAFLA, which says that once a direct appeal has been taken, any issues raised in that direct appeal or known at the time, or any issues that should have been known at the time, cannot be raised in a petition for post-conviction relief. And so, in her denying my petition, she adopted the prosecutor's argument. So that's what the prosecutor argued, that I shouldn't be given the evidentiary hearing because these issues are barred by NAFLA. So what my arguments are on my appeal that's pending right now is that my arguments challenge the jurisdiction of the court, the subject matter jurisdiction of the court. Subject matter jurisdiction is the court's power to even hear a case. So without jurisdiction, the court has no authority to bring a person to trial, let alone convict or sentence them for something. So the court has to have jurisdiction in order to try me. And so by me saying you lack subject matter jurisdiction to even try me or convict me of second-degree murder because it wasn't included in my indictment, which is how you get jurisdiction, I'm raising a jurisdictional defect issue. Jurisdictional defect issues can never be waived, forfeited, or procedurally barred. Okay, that law is widely recognized in all courts in the United States. The federal courts and state courts all recognize that jurisdictional issues can never be waived.
Okay.
So what I'm trying to do right now is I'm trying to get an evidentiary hearing. I'm trying to get the Court of Appeals to reverse Judge Chu's denial of my post-conviction petition and to give me an evidentiary hearing so that my jurisdictional claims can be reviewed. So that's where I'm at right now.
Okay.
I'm trying to get the evidentiary hearing.
So how long have you been locked up so far?
I've been locked up 6 years altogether.
All right.
2 years in the county fighting the case, and then 4 years in prison.
And during the time that you've been locked up, other than fighting to have your case reversed, what would you say that you've done, in since you've been locked up to when you get out to, better yourself, or when you get out and to be a pillar in the community?
Right. So I've undertaken educational courses. I've been studying a lot. Of course, I study the law, but I also study other things. Psychology. I study business. I study a lot on investing.
Okay.
So that I could prepare myself, to be able to support my family, my children, and build financial freedom.
Okay.
And to also be able to uplift my community and bring jobs to my community, and help out, underprivileged communities that need help. I've also been writing a lot because I'm a writer. I write. I'm a songwriter. I'm an author. I just actually finished the first book to a 5-book series that I started, and it's titled Amphibians, The Dark Secrets Deep Down in the Bayou.
Okay.
So I'm excited about that. I'm looking to get that published here soon. So be looking out for that. That'll be out on the shelves and on your online bookstores pretty soon on Amazon and Yahoo.
Okay, that's what's up.
And so, yeah, I be talking to other inmates, younger inmates, trying to be, motivational, you know what I'm saying, and show them, that they can do better, in this type of position, in this type of circumstances, better than what people expect, what the world expects of us, and that there's so many other things that they can do with their lives instead of wasting their time in someone's prison or someone's jail. I try to get them to see, my situation, and the time that I've got, and get them to understand, that, time is a precious thing, and, life is short, and it shouldn't be wasted.
What would you say, what advice would you give to the younger youth that's out here that can end up on the same path as you? What advice would you give them to keep them from ending up in a situation as such?
Well, I would tell them to stop and think.
You have 1 minute remaining.
Think about your actions and the potential consequences that they may have on your life and those around you, because what you do not only affects you, it affects everyone around you.
Correct.
And I would also recommend, that our youth, put the guns down, because guns only lead to tragedy.
Yes.
When they're misused. Just guns were meant to harm, to kill people. They're not toys. So, love each other, love one another, and let's stop this cycle of violence that's tearing apart our communities, because it's not worth it, and life is so short.
All right.
And we're so much better than this for the people.
All right. Well, Landon, I would like to thank you for sharing your story with us. I would love to have you back to do
Thank
a
you for
follow-up.
using GTL.
All right. So I'm going to open up the phone lines if anybody would like to call in if you have any questions, or you could just write them in the comments. If not, I'm going to go on and end the story. So speak now, forever hold your peace. You have something you would like to say?
No, excuse me. I'm just like, it just sounds like, for the most part, he just wanting a lesser sentence for, feeling like he's being discriminated against because of his skin color. It sounds like he definitely.
You can finish.
No, I just sound like he definitely feel like he's being discriminated against from the switching of the court. From the switching of the juries to some of the things not being let into the case.
Oh,
It sounds like that.
A debit call from an inmate at the. This call is from a corrections facility and is subject to monitoring and recording. Thank you for using GTL.
all right. I'm sorry. I didn't know you were going to call back. So yeah, I was trying to thank you for sharing your story with us. It does sound like you're on your education. I'm glad you're doing good things. I would love to do a follow-up with you to see, if anything has changed, if you're going to get any help on your case.
Absolutely. I appreciate that, and thank you. It was my pleasure. Thank you for having me on your show, though.
You're
Giving me
welcome.
this platform to be able to tell my story and to, get the truth out there because I know, the narrative about me and this whole situation is so muddied up and so one-sided. I'm glad I was able to actually, tell my story and tell what really happened and to expose the injustices that's happening to me right now as we speak. And so I just thank you and I appreciate you.
You're welcome.
And God bless you.
God bless you. And we're gonna be praying that you walk out of those gates.
Thank you.
You're welcome. You have a good day.
Okay. Until next time. You too.
All right.
Bye-bye.
So I know a couple people was trying to call and then he called back. So the line is open now. I believe he's learned a harsh lesson. I know how bad it is. I've been blessed to see the outside. We're praying for your safe return, brother. Okay. Let me put the other number up. You guys, I'm gonna put a different number up here. Okay, there we go. All right, you're on the line with Sip and Talk. Hold on, Veronica. I'm
And
gonna put a different number up and have you call that one because this one's not working correctly.
how long did it say that? How long did he say he was like that? He been like that?
6 years in total. Thank you, Chandria. Okay, Veronica, that I just put the different number up. Let me take this off the screen. All right, you're on the line with Sip and Talk. What would you like to share with us this evening?
Okay, you hear me now? Yo.
Yes, I
This is
can.
Veronica.
How you doing? Small
I'm
world.
fine. How are you? Happy birthday also.
Thank you.
Okay. So, basically, he understands that he's not totally innocent in the situation. He understands the situation that happened.
Mm-hmm.
And it's like the what's his name? Podcast lit. No, it's not just the fact of he's saying that he was discriminated against. That's also that plays a part also. But this prosecutor, he literally had it in for him. He told me that he don't matter how many times that it was a hung jury, he was going to bring him back. So basically, it was the hung jury the first time he went to trial. He was found guilty on the gun. It was a hung jury on the murder. They couldn't decide. So the prosecutor was like, I want to take him back every time.
Okay.
That it's a hung jury.
Okay. So
basically, yeah, it was a lot of discrimination going on with that. Judge Chu, she said that she wasn't even engaged in her courtroom with the defense. I had to testify.
okay.
Because, of course it happened at my house.
Mm-hmm.
So it was clearly a case of self-defense. This guy was just shot in the arm, unfortunately. He was trying to hit my nephew with a car. Then he could have killed him with the car alone.
Yeah.
So, yeah, he's fighting for his life.
Understand.
And his family, we're going to stand behind him 100%.
As you should.
So, thank you for having him on your platform.
You're welcome. And thank you for calling
and
in.
everything. You know, I didn't even know you had a podcast. Gina and Tiffany didn't tell me anything. So I'll be checking you out from now on, and I subscribe.
Oh, thank you. You right. Thank you for calling in. I appreciate you sharing your point of view. You have a good day.
All right, you too. You have a nice night.
You thank you. All right. So if there's any more questions or anything, if not, I'm gonna go on and end it so I can go on and turn up a little bit for my birthday. So last request.
Happy birthday, Miss Londa. Gonna kick you for your birthday, and we definitely gonna keep up with all these shows that we do that it's up in our community. You know what I'm saying? So definitely want to go over those more often.
You're on the line with Podcast Lit. What would you like to share with us this evening?
Sip and talk. You been drinking?
Happy birthday, Londa. This is Princess.
Thank you. And I meant to say
What's
sip
going
and
on,
talk.
bro?
Not a lot. Who am I speaking with?
This is Princess.
Okay.
I wanted to call real quick and talk about.
You still with us? Prentice?
Yes.
You said you wanted to.
Yes, I wanted to make sure that I commented regarding the gentleman's circumstance. That there's a lot of this going on. And the worst part about it is circumstance leading to the issue. Now, they don't expect us to be capable of going back to what makes us victims to begin with. And as an adult, I do realize that there is a time where we must take control of our situation. But we need to recognize that those circumstances have been those that we face as African American former slaves, blacks, for a long period of time. And so I believe in the man's innocence, and I believe he should come home.
That's what's up. Thank you for sharing that with us, Prentice. I'm glad that you have faith.
You are absolutely welcome. Hey, happy birthday, lady. Enjoy, okay?
Thank you. You have a good night.
All right.
So I'm going to go on and shut the phone lines down. I'm going to go on and end the live. Until next time, everybody have a good night. See you Sunday. Peace.